and sitting to my left is attorney extraordinaire Benton Watson. Ross, say hi to everybody again.
Hello, everybody, and it's good to be back.
It's always
good
a pleasure to have
yes,
you.
Sir.
I
Yes,
tell
sir.
you what, my back is out, and I know why. It's all that mail I'm getting for you. All
Man,
this
come on.
fan mail. It's just crazy. My back's killing me. All right, let's start it off like this. Ladies and gentlemen, your rights as a citizen here in the United States, they're precious. But they can be stripped from you by committing certain offenses, and it doesn't take much. So I want to go over with our attorney extraordinaire here the progressive levels of offenses within the penal code and see how easy it can be to lose your rights. And as always, Ross is prepared with notes upon notes, and he's going to give you excellent explanation of what they are and what they can do to you. So Ross, without further ado, lead the way. Show us what's going on.
Well, last week we sort of got into possession of a firearm by a felon and some of the consequences of having a felony conviction. And I was trying to leave and you guys brought me back and I was trying to explain, but there really wasn't even enough time then. And then there was more questions even after that segment that came up. And so I felt like we need to go back over some of that and cover a lot of that ground. And there is a lot there, and there really is even too much for me to cover today. But I'm going to hit some of the high points that I think are extremely important, especially if anybody's listening that may have a felony conviction or maybe on probation or something like that. This would be an important episode for you to listen up, or if you know somebody that's in that position that maybe wants their firearm rights back or wants to keep them.
Let me make a note on what you just said there too. Ladies and gentlemen, you can always go to my YouTube channel, Aaron's Gun Shop YouTube channel. We've got all these interviews with Benton Ross Watson and attorney Rick Dodd, and you can look over it, repeat it, replay it, get all the notes that you need to get. So if you miss anything here now, this show will also be replayed next week on KRXT 98.5 FM out of Rockdale. Their shows on that station are 1 week behind. So this show will be repeated again next week on that station. So you got plenty of places. Also to be posted on my Facebook page at aaronsgunshop.com, and you can check it out there. So go ahead, Ross.
Well, we talked about 46.04 of the Texas Penal Code that makes it a crime, a felony, for a person who has a felony conviction to possess a firearm within 5 years from the time either they're sent to jail or released from prison, or when 5 years from the date that they're released from community supervision. And they cannot possess the weapon even after that time if it's away from their residence. Okay, so then we had some questions like, well, the chief brought up some good points about what is a felon, what is the probation versus deferred adjudication, what is the residence, what is family violence, what is the conviction for purposes of the federal law, because we talked about even if the state allows you to have the firearm, the feds prevent you from having a firearm. So today we're going to try to answer some of these questions. The federal statute is 18 U.S.C. 922 G1, and that basically says that anyone who possesses a firearm in interstate commerce, which is basically any time that you possess one, okay, you're going to be in trouble for a felon in possession of a firearm. But then you have to ask, well, what is that? That is a person who is convicted of a crime punishable by imprisonment for a term exceeding 1 year. They don't really say felony. They say a crime punishable by imprisonment for a term exceeding 1 year. And there are some definitions of that, but let's just say, what is a felon, first of all? Well, the Texas law is going to apply to all levels of felony. It's state jail felonies. So you start off with capital felonies. That's, for instance, if you do felony murder, you're committing aggravated kidnapping, and you happen to kill your victim. You kill a police officer in the performance of his public duties. You killed a child, I think it's younger than 6 years old. There's several, but those are some examples. There's your first degree felony is right below the capital felony, and some of those would just be murder, intentional knowingly murder of a person. You're not doing anything other than killing a person. There's nothing else like that. I'm not saying it's a good thing to do. You can still get life in prison, 5 to 99 years. It's some aggravated sexual assault charges or first degree felonies. Also, a second degree felony is the next level of offense. That would be like manslaughter, if you were recklessly causing the death of another human being. Or another would be maybe aggravated assault. That would be aggravated assault causing serious bodily injury. We talked about that. Aggravated assault by threat, but you use a deadly weapon like a handgun. So, and some sexual assaults are also second-degree felonies. Then we go to a third-degree felony. Some of those are like assault causing bodily injury on a public servant, government contractor, or EMS worker, okay, while they're performing their duties. Others are a previous conviction of family violence, and you commit another offense involving family violence, okay? And so then maybe impeding breath, meaning you're choking. Okay, I talked about this. I think this is a big thing because, I mean, my cousin and I'll just incriminate myself because the statute's already run. They can't come get me. But my cousin and I used to fight all the time. And so I used to talk about this when I used to speak for the juvenile departments and say, tell these kids on probation, hey, when you're fighting your brother or sister and you choke them, because that happens all the time, right? We wrestle like WWF, whoa, and you put somebody in a choke move and you think that's funny and you think it's great, but really you're impeding their breath, and that's a third-degree felony. Okay, and so then maybe a state jail felony is interference with child custody. It's just a lower level felony offense. A lot of times, a way that we defense attorneys consider a win is we'll take a really bad case and try to get the prosecutor to agree to maybe an attempt. And a lot of times that makes it a state jail felony or makes it a Class A misdemeanor. Class A misdemeanor would be an assault on a family member. Okay, and then a Class B would be like smoking marijuana. Class C is a speeding ticket. Okay, and
what's a Class C simple assault? Because we state some of that sometimes. Does that go below what you just said of a Class C or above?
There's a lot of times I've heard that there's really no simple assault. So there is a Class C offensive touching.
Okay, because anybody, like if I go, hey, what's up, and I hit you like that on the shoulder.
Well, that kind of hurt. So that was pain, and that was that was an actual assault. But no, I'm just playing. So I'm just sore from golf. Isn't that bad? I'm getting old. The golf makes me hurt. But so those are some of the level of offenses. And let's start with family violence. What is family violence? Because the same applies. If you have a conviction for family violence, you cannot possess a firearm within 5 years from the time you are released from the jail or community supervision, and you can't go away from your house. Okay,
yeah, so how does this work though? If it's family violence and we're brothers and I knock you down or something, and all of a sudden I become a felon, but I'm still living in the same
well, you're
house.
not a felon. You have a Class A misdemeanor for family violence.
Okay, whatever takes my ability to have a gun. Okay, let's say I did something, but I end up going back home. How do you? You're legal. You got the gun, but I'm in the house near those guns. How does that work?
Okay, so I'm going to get to that. We're going to talk about possession, but let's try to stick with what is family violence, because this is kind of important too. It is a household member or someone who you have, or get this, have had a dating relationship. And so the legislature and the courts have interpreted that to mean there is no time limit. So you could have dated somebody 30 years ago. What if you're today's gay, lesbian things are hot? Okay, so what if you have what if you have same-sex individuals in a relationship 30 years ago, and then they come back as two dudes, and then all of a sudden they get mad at each other, nothing sexual, has nothing to do with their relationship. They just get mad because maybe, one almost ran them off the road, right? I understand that it's an assault, but they could claim that they have had 30 years ago a dating relationship. And so that would make them a family member. So, I don't agree with the way that that's interpreted. I think they're going to have problems later on down the line. We just haven't got a good case yet.
That's
okay,
really
but
broad.
Yes, it is. It's extremely broad. But we had a fun case. I tried one of my first cases. I tried with another lawyer, a guy. We were trying to say that it was merely friends with benefits. They were not dating. And the supposed victim, who was the guy on the stand, got up there and said he was creeping. Oh, we had fun with that.
I'd like to be in a courtroom with you, man, a fly on the wall watching this stuff go on.
So I'm telling you, it was great. It was really great. But
you got to watch the video for that, because the whole air quotes thing when he did the creep was just awesome.
So what is a felon then? So we brought up some good points last week, and I hope I'm not running out of time. We should really try to cover this. A felon, if you go to state jail felony, you're a felon. Okay, you go to state jail, you go to TDCJ. You're a felon. You've got a conviction. Probation. Well, we talked about, let's wait on that. We talked about deferred adjudication. Deferred adjudication, right, means exactly what it says. Deferred judgment. So there is no judgment of conviction. Okay, because they have deferred judgment in the case. They placed you on community supervision. You are not sentenced. Okay, and so there is no conviction. And so if you complete your time of community supervision, which is nothing more than probation, okay, stated in a fancy phrase, if you complete that term of probation, then they will dismiss the case. There is no conviction if you successfully complete deferred adjudication probation.
Okay.
Okay, and so you are not falling within that category of being a felon. What about probation? As I said, we didn't mention last time, I said if you have probation, you are convicted. We didn't have much time, but that's not all the way true. Okay, because the legislature has made a way for you to avoid the consequences of having a felony conviction, even if you are on felony probation, if under it used to be 4212, and I'm going to have to look because they just changed the law, the legislature did it. Now it's 42A.701F. So under 42A.701E, it says if you satisfactorily complete and fulfill your conditions of probation, then the judge will discharge you from probation. A discharge is nothing more than a release from jail, because when you're on probation, you're technically sentenced to jail, except they suspend, in other words, probate that sentence and let you serve community supervision outside of jail. So if you successfully complete your probation, then they discharge you and release you from your probation, community supervision.
Got it.
However, 42A.701, the judge may, in his discretion, right, if it's good for the community and if proof that is made known to the judge that the defendant has not been, he's done well and it's good for society to be released, he can set aside the charge and dismiss the indictment. He can do it. And so if that happens, technically there are some cases saying that all of your rights are restored. And so we have this case, Rudy Quillar versus State. It was a 2001 case out of San Antonio. The defendant in 1976 was convicted of heroin. It was a felony. He took probation 3 years, successfully completed it. The judge, under then the 4212, which is substantially the same provision that I just read under 42A.701, set aside the conviction and dismissed the indictment. Later on, 20 years later, in I think it was 1996, the defendant Mr. Quillar was riding in a passenger car that got stopped for speeding, just some regular traffic stop. And the police officer asked some routine questions of the passenger, which was Mr. Quillar. He said, "Hey, do you have your ID? I just want to identify everybody." Ran his name. He was a felon. So this cop says, like a good police officer, I'm not knocking the cop. That's what he was supposed to do. He's going to ask him some questions. "So, you're a felon. You got any firearms in the car?" Mr. Quillar said, "Yeah, we've been hunting. I got my hunting rifle right behind my seat." So, "Well, you're going to jail." And he got him for felon in possession of a firearm. Mr. Quillar right then filed a motion and dismissed because under that statute he said that he couldn't be charged. The trial judge actually upheld it. He dismissed the case. The state appeals to the appellate court. The appellate court upheld the trial judge. It goes to the Texas Court of Criminal Appeals and they reversed. They overturned it and sent it back. There were some other issues in that case. I'm just going to tell you all the hardship. I wanted you to see this. It got sent back all the way down. They had to start over. He got re-indicted. Well, you can get re-indicted, but technically, however you want to look at it semantically. Okay, they start the case over. So he's back in front of the judge. He files, his lawyers this time, they do a strategic move. And they said, we're going to avoid jury trial. We're not going to fight the state. Right? What we're going to do is plead guilty and then plan an attack on appeal. So they did. They pled guilty. What was their plan? Well, they were going to say that
This is the Aaron's High Cap Adventure Radio program. He's checking his notes.
They allege that the state failed to support the conviction with sufficient evidence to demonstrate that Mr. Quillar was actually a felon because it had been set aside. The charge was set aside and the indictment was dismissed, very similar to a deferred adjudication. And the state says, no, this was probation. If the legislature meant for this to be like deferred, they would have called it deferred. This is not what it was meant. And the appellate court disagreed. The appellate court said the language is clear. And it goes, and he wins on appeal, and it goes up to the Texas Court of Criminal Appeals, and the Texas Court of Criminal Appeals said the same thing. The language is clear. But why I want to emphasize this case is because that costs so much time and money and hardship. And I want you to listen to what the words of the Justice Green in the San Antonio Court of Appeals. And keep up with me, it's just one little paragraph, but I want to read this because it was the end of the case and he was trying to make a point. This case is troublesome because it is uncertain why Mr. Quillar was charged with a felon in possession offense, much less actually tried for the offense. The law is straightforward. The Article 4212 order should have been sufficient to shield Mr. Quillar from any criminal charges stemming from the nullified 1976 conviction. Under the circumstances, Mr. Quillar was not mistaken in his assumption that it was legal for him to possess a hunting rifle. And despite some sentiment elsewhere around the nation to the contrary, it is still perfectly legal in this state to possess a hunting rifle if you are not a convicted felon. Notwithstanding, it appears the state insists on its relentless pursuit of Mr. Quillar, and that being so, the state's initial promise to Mr. Quillar that he would have a clean slate if he successfully completed probation was, as we see now in the end, an empty promise.
Wow. You're passionate, dude.
But that's what I'm saying. You say the language is clear, but you're always going to have an overzealous prosecutor that's going to try to take it to the next level. And we don't know why. Maybe he was not a favorable guy in the community. I don't know. Maybe they were just...
I was looking at the newspaper article, or heard a news ad or something, I forget what it was, but some guy had to go to court 3 times for the same problem because they kept retrying him. It's like, my gosh, you're just going to keep going until you get the guy. What happens to just going to court, doing your job? He's either guilty or he's non-guilty. And it's basically the same thing here. It just keeps going up. They want to win, and they'll do whatever they can to win just so they'll look good. That's how it appears to me anyway.
But then he was right because they appealed it again to the Texas Supreme Court, like I said, and they upheld the decision this time, and what they say is very important. This is important. The underlying purpose of the community supervision is to provide criminal defendants with a chance to mend their ways. If a defendant, like the appellant Mr. Quillar, accepts the challenge, if he accepts that challenge and successfully completes those terms and conditions of community supervision, he should not be stigmatized for the rest of his life. Such persons have demonstrated that they are ready to rejoin the community as law-abiding citizens. Accordingly, we have recognized that once the conviction is set aside, persons previously convicted of felonies can serve on juries and vote in elections. And if they can do that, there is no reason why they cannot carry a hunting rifle. Powerful. I'm proud of the courts for what they did here.
You hear that passion in his voice, ladies and gentlemen. If you got a challenge, if you got a legal problem, you need to call this man. He's extremely passionate.
Ross
Watson.
There was some other cases that were on the federal level. I'm not going to talk about them as in depth, but United States versus Fix was also a 2001 case. Now it's a little unclear exactly how the feds are going to interpret that provision under the new statute and whether it's going to be exactly the same as Texas. But Texas law controls, and so it should apply in the same way. But in Mr. Fix's case, he didn't go under that provision. He actually got a new trial. He got his lawyer to get the district attorney to agree to grant him a new trial and then try to dismiss it. And he tried to make the same argument Mr. Quillar made and buttress it with that opinion. And that really didn't work. But the court still upheld and cited those opinions later in a Chalmers case in 2002 for the proposition that in either case you can still regain your rights as a citizen, even if you have because he did have a felony conviction. You see, he got a new trial. Mm-hmm. So, but in those two circumstances, it would be possible for even if you had an initial felony charge or conviction, right, to have it then set aside under that article of 40. I can't ever remember the new one. Just what is it, 42A.701? That's it. So and. I mean, if you're one of these people, you should really look into this. And then we talked about getting a pardon. You can make an application. And for certain juveniles, there's what's called an executive clemency. There's also a pardon, I'm sure, for juveniles as well. I haven't ever had to try to go that route. But there is also an application that you can make for restoration of rights. You can make that to the Board of Pardons and Paroles. Don't really do many of those. A lot of times the guys specialize in that and do just a ton of cases and make a lot of money. But I maybe I should look into it. But I can help you with that. But regardless, if you think you're in one of those situations, you can just Google, and I'm sure you'll find somebody that is local or close by. I'm sure there's a bunch in Austin.
This is incredible. This is information overload. It's like there's so much out there that you don't know, or you have an idea, but then all of a sudden, like you're talking about in this situation, it just keeps getting twisted or turned around and off of what it should be really doing based on what the law says. So there's a lot of people out there who get frantic or lost, and they got to find somebody who knows what they're doing. That's why there's people out there like you with such a passion who can clear it up, talk about it, and ensure this is the rights that you do have. Let's not get them stolen or covered over. And people just need to know that if you do something that causes a mark on your record, you need to find somebody who really knows what they're talking about to protect those rights that you have.
Last, I want to mention, because we talked about this last time, and you just mentioned it again today. I want to make sure people know this. So the felon in possession of firearm doesn't say anything about felon owning a firearm. Nothing's preventing you from owning it. Preventing you from possessing it. And I think you had asked me at some point, maybe last week or this week, whether somebody could shoot it for fun. No, that'd be possessing it. Okay, so you got to ask yourself, what is possession? Well, obviously, if the person's carrying the rifle on their person, and I'm not going to get into carry. Yeah, there's actually been some lawyers make some winning arguments about their client wasn't carrying it. I thought that would be a straightforward issue, but not all the time. But carrying it, if you're carrying on your person, right, that's being in possession. But what else? Well, we look at it under drug possession. If in other cases, like you said, if your wife is not a felon and she lives in the house and she is an NRA member and she's gung-ho about gun rights and she has her own weapons, is your presence in the house and knowledge of the guns being in the house make you responsible? Again, take what I say and remember that an overzealous prosecutor can try to make a case out of whatever he wants. But I will say that there have been many cases say that it is like drug possession. So that means that the accused person must know of the existence of the weapon, right? And that the accused person has exercised care, control, and management over the weapon. And so if it is in a house and it's in your wife's safe and you never go in there, okay, then I don't think you meet that second element at all. If it's hers and she manipulates it, she handles everything and she does it all, okay, then I don't think that there's any question that you don't fall within number two. A good thing to do if you're worried about it is to put your guns in a storage safe or give them to a family member and say, hey, hold it for me until 5 years comes up and then give them back to me. But remember, there is really no exceptions like there is for regular people that are not, I say regular people, you're regular people if you have a felony conviction. I don't mean to say it like that, but people who are non-felons, okay, or have been given clemency or something like that, right? We have exceptions even when we otherwise maybe possess a gun illegally for traveling purposes. Maybe if we purchase it at the place of purchase, like Academy, you go to Academy, purchase a gun, we can have it out in the open. Okay, if you can also carry it between your business and your house, or you can have it out in the open maybe when you're moving from house to house. Those do not apply to a felon in possession. So you better tell your family member to bring the guns to you, okay, because you can't go get them, okay, and then take them back to your house. There's not those exceptions available for a felon. At least that is not what the courts are saying. It's a literal interpretation of that statute as well. They don't even have to prove exactly what house you were in. If they got evidence that it was away, that would be yours to prove.
And I'll tell you why I've asked this so many times. It's because I get so many questions about it, and that it's unfair for the person who does not have the felony to have to do extra stuff if it's almost like their rights are being covered over because of the offense of somebody else who's got the felony. So if you're in the house and you're all related, and the person without the felony's got the guns, but the person with the felony is not supposed to be near the guns, it seems unfair for the person who didn't do anything wrong to have to make special adaptation to the environment to make sure that this individual doesn't get in trouble.
Right, and I will say there is a case, yes, there is a case talking about the environment because there's circumstances, that's what they have to use to link it. And there was a case, a win, I can't remember what year, but it was around 2003. He was in a car that got pulled over, and he was aware that the weapon was in the car, and it was a prohibited weapon. And they found that there was sufficient evidence of his awareness, but they said that it was insufficient for the conviction, and they overturned it and granted a new trial. Remember, he wasn't acquitted. He didn't get found innocent. They had to go back, and then the state got a second bite at the apple. Okay, so then they had to go back. The car was only pulled over 20 seconds. It only took it to pull over, and it was only a speeding charge, and they didn't see him with the firearm, and it wasn't his vehicle, and there were other people in the car. And so his claim that it wasn't his vehicle and he didn't have custody management and control over that weapon would have been sufficient to find him innocent.
Okay, Ross, this is excellent. This is our cue. We're going to be breaking real quick. Why don't you tell everybody how they can get a hold of you? And if you need some help, Ross is the man to talk to.
Benton Ross Watson, primary office location is here in Cameron. I work at several different locations in the state. 105 East Main Street, Cameron, Texas, 76520. Phone number is 254-605-4140.
Capellino,
Fantastic.
Todd, Krebs, Law Firm.